Amicus Curiae further alleges that the trial chamber erred in its decision denying Krajišnik's request for self-representation. He does not show, however, that a request for self-representation must always be honored in the absence of persistent obstructionist conduct on the part of the accused. This subground of appeal is thus dismissed. Amicus Curiae further argues that the judges of the recomposed trial chamber erred in law by ordering the resumption of trial, although it was obvious that Judge Hanotu, the substitute judge, had not acquired the requisite familiarity with the case. Amicus Curiae, however, fails to bring forward any evidence that Judge Hanotu had not sufficiently familiarized himself with the case to be able to properly discharge his functions. This subground is dismissed. For the foregoing reasons, the appeal chamber dismisses Amicus Curiae's assertion that Krajišnik's trial was unfair. That said, the appeal chamber notes that certain aspects of the conduct of the trial were not free from defects and may have created an appearance of unfairness. However, based on a holistic assessment of the trial record and the additional evidence on appeal, the appeal chamber is not satisfied that Amicus Curiae has shown that these defects amount to a miscarriage of justice which would undermine the fairness of the trial received by Krajišnik. This ground of appeal is therefore dismissed in its entirety. In the second ground of appeal, Amicus Curiae submits that the trial chamber erred in law by failing to provide a sufficiently reasoned judgment and to give reasons as to why certain witnesses or exhibits were found credible and others not. The appeal chamber notes, however, that the trial chamber specifically stated that it had carefully deliberated on the evidence presented to it. The impugned passages merely stress the fact that the trial chamber could not present and discuss all the evidence in the judgment, a statement which cannot by itself be equated with a failure to examine the evidence in question. Hence, the second ground of appeal raised by Amicus Curiae is rejected. In his third ground of appeal, Amicus Curiae argues that the trial chamber did not correctly identify the participants in the JCE and could thus not conclude beyond reasonable doubt as to the existence of a common objective between them and Krajišnik. The appeal chamber finds that the trial chamber indeed erred in failing to specify whether all or only some of the local politicians, militaries, police commanders, and paramilitary leaders referred to in paragraph 10887 of the trial judgment were JCE members. This subground is thus granted. Amicus Curiae further alleges that the trial chamber erroneously failed to make findings as to when the murders formed part of JCE and could thus be imputed to Krajišnik. In this context, the appeal chamber first notes that it is satisfied that the trial chamber found that Krajišnik shared the intent to commit the original crimes of deportation, forcible transfer, and persecution based on these crimes from the beginning of the JCE. With respect to the expanded crimes of murder, extermination, and persecution based on crimes other than deportation and forcible transfer, the trial chamber generally found that they were added to the JCE after leading members of the JCE were informed of them, took no effective measures to prevent their recurrence, and persisted in the implementation of the common objective, thereby coming to intend these expanded crimes. The appeal chamber notes, however, that the trial chamber made only scarce findings if at all, on these requirements. Therefore, the appeal chamber is not able to conclude with the necessary preciseness how and at which point in time the common objective of the JCE included the expanded crimes, and consequently, on what basis the trial chamber imputed those expanded crimes to Krajišnik. Neither the appeal chamber nor an accused can be required to engage in speculation on the meaning of the trial chamber's finding, or lack thereof, in relation to such a central element of Krajišnik's individual criminal responsibility as the scope of the common objective of the JCE. Thus, the appeal chamber finds that the trial chamber committed a legal error in failing to make the findings necessary for Krajišnik's conviction in relation to the following expanded crimes, which were not included in the original common objective of the JCE. Persecution, count 3, with the exception of the underlying acts of deportation and forcible transfer. Extermination, count 4, and murder, count 5. Consequently, the appeal chamber grants this subground of appeal in part and dismisses its remainder. Krajišnik's conviction for expanded crimes under counts 3, 4, and 5 are thus quashed. Michael Scurria further argues that the trial chamber erred in law by holding that a JCE member can be criminally responsible for the acts of persons who were not members of the JCE and who potentially did not even know of the existence or purpose of the JCE. Michael Scurria avers that the trial chamber erred in departing from the Bosnian appeal judgment and that it failed to find the existence of a link between Krajišnik and the crimes. The trial chamber held that a JCE member could incur liability for crimes committed by principal perpetrators procured by a JCE member to commit crimes which further the common objective. The appeal chamber is satisfied that this standard corresponds in substance to the standard outlined in the Bosnian appeal judgment, which was rendered after the trial judgment in the present case. Michael Scurria therefore fails to show an error by the trial chamber in this respect. The appeal chamber observes, however, that on many occasions the trial chamber erred in failing to reach any finding on the link between the principal perpetrators of the original crimes of deportation, forcible transfer, and persecution based on these crimes, and the JCE members. As a result, the appeal chamber concludes that the trial chamber made only findings that the following original crimes were committed by JCE members by using principal perpetrators in furtherance of the common purpose. Persecution by way of deportation, count 3, in Bratunac, Zvornik, Sanjski Most, Banja Luka, Bijeljina, and Pnjavor. Persecution by way of forcible transfer, count 3, in Bijeljina, Bratunac, Zvornik, Bosanska Krupa, Sanjski Most, Črnovo, and Sokolac. Deportation, count 7, in Bratunac, Zvornik, Sanjski Most, Banja Luka, Bijeljina, and Pnjavor, and in human acts by way of forcible transfer, count 8, in Bijeljina, Bratunac, Zvornik, Bosanska Krupa, Sanjski Most, Črnovo, and Sokolac. Krajišnik's convictions for the remainder of the original crimes under counts 3, 7, and 8 are thus quashed. Furthermore, Michael Scurria alleges that the trial chamber erred in law by failing to make the relevant findings on deportation with regard to each municipality. The appeal chamber finds that the trial chamber indeed failed to always perform the required analysis of whether a sufficient de facto or de jure border was crossed, and that the findings on deportation from Jelina, Mratnac, and Zangsi Most must fall. Consequently, Krajišnik's convictions for these crimes are quashed. However, the appeal chamber is of the view that the trial chamber found that forced displacements of persons across the jure state borders occurred in the municipalities of Zvornik, Banja Luka, and Prešňavor, amounting to deportation. This ground of appeal is thus granted in part. Next.